Welcome everyone to this session entitled How to Keep Yourself and Your Boss Out of Jail. I hope you've got your notepads ready, okay? This one is going to be fascinating. Hearing from speaker Melanie Newman from Matrix Sciences International. And in addition to our great speaker, we're going to have Leanne Chuboff join her for a live Q&A. Your questions answered. So all you no-go jailbirds out there, come on, keep the questions rolling in. And by the way, this session also comes with small group breakouts at the end of it where you can discuss, share best practices, get to know each other a little bit more. So without further ado, welcome Melanie to the stage.
Thank you, Rachel. Appreciate the kind introduction, and thanks to SQF for inviting me back to speak at your annual conference this year in 2021. As we've been seeing, this has been a unique year, just like 2020, and hats off to everyone and applause to all of you to pivot and to attend virtually, and to SQF for being able to make such a spectacular pivot in a short period of time. So let's dive in. Let's dive into this topic that some of you may have thought was a little bit interesting to see on the agenda. Maybe direct. Well, any of you who know me know I'm a fairly direct kind of gal. So the intent really here is let's not wear orange. Do you look good in orange is the question. we want to stay very clear from that. But I will also say that this isn't meant to be a scare tactic by any stretch. This really is to try to educate and bring a broader appreciation for the various kinds of risks that we as food safety professionals are asked to manage every day, as well as our bosses and our leadership. And how do we help not only ourselves, but our leadership do the best possible and informed job of managing all the various kinds of risks around us in a way that not only keeps us out of jail, but also raises a different kind of bar, not jail cell bars, pun intended, but the bar to elevate food safety. And so that's really what the focus of this conversation is about. If we can go to the next slide, we'll dive in and figure out what the heck we're even talking about here today. So why are we talking about what we're talking about? There's a perhaps not as broad of an express appreciation for what the phrase legal compliance means. We see this phrase, this representation, this warranty in contracts and terms and conditions, in documents flying, through our supplier approval processes and our vendor setups and so forth. And do we stop long enough to really analyze, what does it mean? What am I signing up for? If I have signing authority for an agreement or a purchase order or terms and conditions, what am I signing my company up for by way of saying, yeah, we comply with all applicable national, state, local laws? Sounds like that's a fairly tall drink of water, and we're gonna talk a little bit about why it is. And I'm gonna give you some examples. I'm gonna give you some examples of some situations, some recalls, some case law, to be able to better illustrate what we're talking about here, including how we really help our leadership understand and grasp perhaps the gravity of a food safety risk. And so some of these examples are going to be almost a calculation or an algorithm of how do we translate hazard to risk? How do we talk about a food safety hazard like listeria and explain it in terms of risk that a CFO, a COO, a CEO will get? And frankly, right, wrong, or indifferent, for better or for worse, those folks deal in risk at a fairly objective level, which frankly is a dollar value. And we're gonna give some tips and some examples of how we can translate hazards like listeria into financial risk that may impact our bottom line. And then lastly, I'm gonna give you some tips and some strategies to consider for analyzing contracts, looking at terms and conditions, having a better appreciation for what this means, so you're able to be armed and ask better questions of your colleagues, of those in your C-suite, and of those below you, to really understand that we can agree to these terms. We are in legal compliance, in other words. But in order to get to that finish line, we really need to kind of dissect what that means. And that's the purpose of the conversation here today. So if we go to the next slide, this slide really is to try to give you this macro level appreciation for why we're even talking about this. Because you and your boss are managing risk from multiple different angles. Some of these risks are governed by regulation. Some of these risks have are governed by contractual terms and conditions. And some of these risks are just simply reality. You know, for example, labor and environmental health and safety and supply chain disruption. We're seeing this at its peak of probably what we ever imagined we would have to manage in our lifetimes due to the global pandemic. We see risk and have to manage risk every day with regulatory agencies, increased inspections, swabathons, and then the reality or the outcome of the results of those efforts. We need to deal with new and evolving regulations. Right now, you know, what's kind of hot on the circuit being talked about is the proposed traceability rule. How will that impact you? What risk do you have to mitigate as a result of how that rule will become final? Will we have to convert to technology? Where do we run afoul of a regulation, and then all of a sudden are not in legal compliance anymore? We have other risks we have to manage every day, particularly driven by our customers and our consumers. Customer and consumer demand really set the bar, or the ceiling, if you will, of the standards we need to meet. The regulations, frankly, are a bit of the floor. And ultimately, some of those high standards being influenced by customers and consumers can still run us into situations where we find ourselves in recalls with media picking up those recalls and perhaps mischaracterizing it or blowing it out of proportion. So we've got reputational damage, that risk that we have to mitigate and watch for. We've got consumer advocacy groups that are pushing and pressing on issues such as, you know, organic arsenic in infant cereals and so forth. And ultimately, we've got the overarching risk of a Department of Justice action. If we step too far sideways, there's civil, there's criminal sanctions that the Department of Justice is empowered to take against us, against our bosses. And a classic example here is Think Peanut Corporation of America. You know, Stuart and Michael Parnell, the quality assurance manager, Mary Wilkerson, all in jail. Yes, that was an egregious case. That was knowingly distributing adulterated product into commerce, but it does illustrate the risk in totality that we have in producing food every day. And so I think understanding and having this foundation of these multiple kinds of risks really just helps us appreciate the stress our leaders are under and the need for us to help ourselves to help them understand risk when it comes to food safety, and then help appropriately resource that risk, whether it's additional headcount, whether it's a capital expenditure approval to get a new piece of equipment that might be causing an issue, but to ultimately understand, appreciate, and appropriately resource the situation and the risk. Because on the next slide, we're going to see that some of us may think we want our boss's job, but we may want to be sure we recognize the reality of the risks that have to be weighed, and the risk ratio reward to producing food. There's a risk of going out of business every day, folks, right? And that your leadership, for all the right reasons, needs to keep their eyes on, right? We could go out of business because of a supply chain disruption, Maybe we all of a sudden can't get an ingredient that's ubiquitous in a lot of our products. And the one supplier who was out there who sourced it now is down because their production facility is down due to a COVID outbreak. Or, maybe it burned down due to a fire, or with all of these, natural disasters and major storms around the world, a lot can really happen overnight. And overnight, we could find ourselves in such a production constraint that due to the supply chain disruption, we could go out of business. So they have to keep their eyes on supply chain needs, on commodity prices, on how they could maybe hedge some risk in the market, right? When we think, I'm so frustrated because my leadership isn't listening to me for the needs to manage food safety, I think that's a very real and a very appropriate frustration, but understanding the competition you're in for that finite focus and for the finite pennies in the piggy bank by way of resources, having this understanding of how it all kind of fits together, I think is going to become very helpful, because you can see all of, this is just an example of one, 6 of probably 600 risks that are moving around and need to be balanced every day. I mean, and it goes from the extreme of having to pivot with supply chain disruptions all the way to the risk of going out of business because we make people sick and die. I mean, obviously, no CEO in the land wants to take on that risk. So how do we have the conversation with them to help them understand when is the risk will never be at zero risk. There's always going to be some residual risk, even when there are appropriate controls in place. The only way we're at zero risk in producing food is to stop producing food. Might be my personal opinion, but show me a facility with zero risk. Haven't seen one yet. But we need to, I think we need to be able to weigh and present a business case in a way that recognizes, hey, we know risk is relative to other risks to the company. We know that every single day, 365 days a year, we may not be the highest risk in food safety. People safety might be because of COVID. Cybersecurity might be because we recently had a ransomware attack. But again, going back to building that into your business case, I think brings a lot of street cred or street credibility to you when you do go ask for support. So let's talk about legal compliance. We talked a little bit about the risks around us, but now that we've got a common foundation of what we have to be balancing and the various kinds of risks that need balancing, what kind of risks are we taking on when we maybe just fly by the phrase, I agree to abide by all applicable laws and regulations associated with, and then usually there's a million miles of text. So on the next slide, it just summarizes kind of the common or leading definition of legal compliance. It's a process. It's a process by which your company adheres to laws, regulations. I was about to say directives and guidance, but that is not law or regulation. But sometimes regulators view it as such. That the company needs to follow to run their business and to stay in business in a particular jurisdiction. So if your headquarters are in the United States, everything you do needs to abide by, that has a law or regulation attached, needs to abide by the US laws and regulations associated with that activity or function. If you also have offices in Germany, in Canada, and in Mexico, you need to abide by those local jurisdictions' laws as well. Same holds true for food. From a food law perspective, we need to be able to comply with the laws and regulations of making food and food safety, both in the country of manufacture and in the country of distribution. So if we make food in the United States and we export it to Canada, Mexico, and Germany, we need to make sure our product's appropriately labeled for all of those jurisdictions, right? We need to make sure that we're abiding by all food laws in those various countries as well as in the US. And so when we make the representation that I'm in legal compliance, how do you know? We'll talk a little later about some tips and strategies around how you can know. But this is the struggle. This is the evolution of being able to demonstrate compliance. And that's very key. It's the key here on the slide is that legal compliance isn't static. It isn't a finish line where you stop running. The race is never over. This is something that is constantly moving because there's always new laws in the hopper, I call it, right? There might be proposed bills and legislations in the House or in the Senate or in some variety of the, when a bill becomes a law, and I'm dating myself with that little cartoon. But notwithstanding, we need to have a process in place that can demonstrate that we know and understand the laws that we're subject to. And so it ultimately results in, just like FDA and USDA inspections, just like SQF certification requirements, if it's not documented, it didn't happen, folks. So how are you going to be able to demonstrate compliance? Well, within food law and regulation, for example, if you're FDA governed, we've got the preventive controls rule, right? That requires us to do a hazard analysis and have a food safety plan for hazards that require a preventive control. And then there's the associated requirements for monitoring, record keeping, verification, corrective actions. All of those documents become our demonstration of legal compliance to that food law and regulation that's expected of us. That's why it's so important to keep those records, to keep them real time, to not backfill them at the end of a shift and pencil whip in data, because it isn't this process of demonstrating legal compliance. I know I talk with my hands and I get really passionate about this, but I think sometimes when we don't convey the why, well, it's, you have to keep that record because we have to. It's required. It's required by law. Well, why? Like, what happens if I don't keep this record? Does it spontaneously combust and cause a fire? Do I get beamed up to Scotty? What happens? And I think taking the natural conversation to its natural finish line of, we're out of legal compliance. That means we could be viewed as breaking the law. And there's going to be consequences to that, from all the way up at the C-suite, all the way down to the operators who are a part of that process. Can't guarantee there's going to be consequences, but if the misstep's big enough and the resulting impact to illness or injury is bad enough, say someone dies, the higher the likelihood is someone's going to come looking for someone to blame. And if we don't have a way to demonstrate compliance, we're basically out of compliance. So I won't belabor that dead horse or beat a dead horse, or in this case, a live elephant. So I think on the next slide, all of this is to say that your leader's job is like asking an elephant to balance on an inflatable beach ball. And I don't know about you, but I don't have that great of balance. and it takes practice to do that, right? And so it takes practice to, what I mean by that is, that's where like your internal audit programs come in, your self-assessments come in, the records review that PCQIs do on the monitoring, verification, corrective action records that are built into the law. But it's also really good practice, because that's the practice that you need to understand, are we balancing on this really soft and could pop at any time object under 1 foot as we're trying to balance an elephant on it. Maybe a really poor analogy, but there's something that resonated about this picture that made me really appreciate my leader's role and job, and the fact that there are days where I don't know how he does it. And I think you can all appreciate, probably there are days you don't know how you do it, and you don't really know how your bosses do it, but you do it. And it's through this repetitive documentation and demonstration of compliance. So I think the other thing this image really brings to me is that we really need to do what we can to help our leaders understand the true risk when it comes to food safety. So how Sorry about that, folks. If we go to the next slide, we're going to talk about what legal compliance is. We've touched on it. I think in summary, my answer is of how legal compliance is defined is very carefully and often confusingly. I like to break it down to the 4 E's. Legal compliance is either established, it's explained, it's expanded, or it's encouraged. And so each one of the colors of those words map to an example in the right. So established, those are laws and regulations. Congress establishes a law. They may empower a regulatory agency like FDA, USDA to enact a regulation. We have areas that help explain legal compliance. So for example, the regulation, it further elaborates on the law. So the law establishes a requirement. A regulation typically is more meat on the bones to explain that requirement. And then it can be, these laws and regulations or expectations can be further expanded upon via contract. That's that example of a clause we see very often is our company agrees to abide by all applicable laws and regulations. That's a short sentence with a lot of responsibility attached to it, which we'll dive into in a little bit. And then legal compliance can be defined by stakeholders who encourage, who influence laws and regulations. Like, for example, GFSI and SQF, CDC. CDC is not an enforcement authority, but they do help collect a lot of very meaningful data to influence laws and regulations, for example. So we'll walk through some examples. But on the next slide, I thought it'd be interesting to note, fun fact, did you know that the term legal appears in the SQF code 16 times? That was the manufacturing edition 9. So my disclaimer is I did a Control F, looked for the word legal, popped up 16 times. There's a couple of examples from the SQF code directly that refer to this as well. So when you sign up to be an SQF certified facility, you know, one of the things you're signing, you're raising your hand and pledging is that, you know, you are in legal compliance. And so hopefully this conversation and some of this information really helps you better understand what that means, the importance of it, and perhaps what an SQF auditor is going to be looking for in order for them to say, yes, I believe this facility is in legal compliance. SQF defines legality. Like I said, there's different definitions of legal compliance. It's all predicated and based and influenced on law and regulation, but again, on other stakeholders who influence like SQF. So it's really important to understand what definition are you playing by? What do you need to be complying with is one of the reasons I think for this slide. So if we go to the next slide, we'll circle back to the laws and regulations that establish legal compliance requirements. So the term adulteration and misbranded really are at the center of this when it comes to food law, to to achieve legal compliance for food laws and regulations. And that's, these terms are defined in a variety of different regulations. So they're in the Food and Drug and Cosmetic Act, they're in the Meat Inspection Act, they're in the Poultry Products Inspection Act. The punchline really is in the next couple slides. So this is just takeaway information for what the term adulterated food means, as defined by the US Code of Federal Regulations. And as you will see in the next slide, there's a lot. There's actually 2 slides worth of information that defines adulterated food. I am not going to read all of these to you. Those that are highlighted in blue are ones I just wanted to point out briefly, because they're ones that FDA is more recently pointing to, hanging their hat on, to cite observations and findings in 483s, in violations for warning letters, for example. We often talk in terms of adulterated food only with respect to that very first entry. That's the common definition. Is there something bad in here? Is there a poisonous or deleterious substance? Deleterious means injurious to health. So there'll be a couple of examples of this on a couple of upcoming slides here. But that's usually where, like your listeria, your pathogenic organisms fall. But take a look a few bullet points down for the entry around otherwise unfit for food and may be injurious to health because it was held under insanitary conditions. These are a couple of additional definitions for adulterated food that at least the FDA is getting more active around. They're actively looking for these kinds of situations and inspections and citing facilities for them. And this is just an awareness to say, this too is technically non-compliance. It's a violation of a regulation. It's a violation of a law to avoid the distribution of adulterated food. If we go to the next slide, it just continues the definitions. The second bullet point it's just one of my things I do. I like to point out that this does not mean irradiation, like irradiated spices, for example. This means actual radiation like Chernobyl. So it's important to kind of keep that differentiation in mind. But if we go to the next slide, we talk a little bit more about what does the code, what does the law require? So the definition of misbranded is here. So it's basically anything that's false and misleading in any particular is the way that the law is worded. If it's offered for sale under a different name, if you're trying to offer this as a crab meat and it's really imitation crab meat, mislabeled, ergo imitation of another food. You have requirements that all required labeling elements are on the label that are required by the law, that are required by USDA or FDA. And if they're not, products misbranded, it's a violation of a regulation. If we go on to the next slide, this is where some examples are built in. So like, as I mentioned, the poisonous or deleterious substance, that's a lot of the pathogenic organisms that can make people sick. In sanitary conditions, there's an example of a couple headlines that are pasted on the right side of your screen. And the first one was just as recent as the 1st of October of this year, where US Marshals came in and seized spices and food additives that were held under insanitary conditions. Under this definition of adulteration, they don't need to find actual contamination. They don't need to find actual adulteration in your product, in an ingredient, in your facility. If they believe that a product is if the inspectors believe that a product is being held under insanitary conditions whereby it may render the product injurious to health, that's all they need. Sounds like a pretty low bar when you think about it, right? It is. As you can see, egg rolls were recalled for being packaged under insanitary conditions. No evidence of finished product contamination, no evidence of environmental contamination, just insanitary conditions. Now, insanitary conditions can be evidenced by environmental monitoring results, environmental swabs FDA takes, for example, but it could just be bugs, pests, a very dirty environment, maybe one that's open and exposed to outside external environment and those environmental contaminants. So we should be very mindful as we're working and walking through our facilities every day of what could expose us to risk. Like where could I be out of bounds on legal compliance just by leaving the back dock door open when it's, I don't know, warm outside and it's, cold inside or vice versa, could be enough. It's kind of scary to think that we don't have to walk too far sideways to be way out of bounds on some of this through the eyes of the beholder, right? So every inspector is going to have a little bit of a different viewpoint on where they think they have enough to cite this particular part of the definition versus maybe some other sections. So if we go to the other ways in which legal compliance is defined, contracts can explain or expand on our requirements. So in the next slide, this is the proverbial contract clause I've been repeating over and over again. But this is an actual example from a contract that I reviewed for one of my clients. And ultimately, it's your classic agreement to comply with all applicable laws and regulations. In this case, we got lucky enough that the phrase was defined. It was defined in the contract that applicable food laws means the following. Just take a look at the words in orange. And I promise I'm going somewhere with this. But if you signed your John Hancock to this, what did you just sign up for? What did you just agree to? So if we go to the next slide, I broke it down a little bit. So you said you agree that you comply with all applicable laws associated with use, with growing, manufacturing, harvesting, labeling, storage. And beside each one of these nodes, these process steps, these items are laws and regulations that go along with those actions. And so at the end of the day, you're saying, I comply with all FDA regulations if I'm an FDA regulated facility, including without limit, any and all FSMA rules that may apply to me, all the food and color additive regulations, all of the Federal Food, Drug, and Cosmetic Act 1938 underlying expectations. That means all labeling laws. That means FELSPA and the allergen labeling laws. And, there's a term where I said I'm agreeing with all laws associated with licensing. Well, now you're pulling in Uniform Commercial Code and Contracts law. You may be pulling in Lanham Act, which is the federal trademark law. I'm not going to, take too much time on this slide, but I think it's impactful to see just what you're signing up for when you're like, yeah, we do all of that, sign, here you go. And so this is where asking questions, hey, you know what? I'm not so sure about our practices in distribution. I don't know if we own our own fleet, if we contract with a third-party carrier. Boy, I can't really say maybe we aren't in compliance with the Sanitary Transportation Act. Maybe, I wonder if we even have a license for our storage facility. Start asking questions. It behooves you to speak up versus sit back. You're more at risk for not saying something or not asking questions than just thinking someone else has got it handled. And I think with that understanding of all of the moving parts, all of these risks, The types of laws and regulations you're agreeing to when we agree to phrases like I agree that I comply with all applicable laws and regulations, what that really means. What if I'm not? What if I'm not in compliance? Well, the next slide just summarizes some of the impact. There could be regulatory violations, it could trigger a recall. We could have caused a foodborne illness outbreak. People could be sick. There could be lawsuits. There could be, FDA could seize my product and in come the US Marshals, for example. I could be fined. I could be criminally or civilly prosecuted and see jail time. My facility could be shut down. Now, obviously, these are levels, various different degrees of gravity when it comes to the impact. And again, this was never meant to be a scare tactic, but I think it's important to understand that we have a lot of responsibility. And this isn't so that everybody says, I decide to quit and just go be a barista at Starbucks. Starbucks is a wonderful place, and we don't survive without them. This is to give you, I think, a better appreciation for what you do every day to protect the food supply, to protect your company, to protect it from legal risk, from operational risk, from reputational risk. And you're protecting the consuming market of your product at large as a result of that. And I think that's pretty brilliant, and you deserve a round of applause. And lastly, you know, if you're asking yourself, great, now you've scared me half to death, what do I do now? There's a lot. There's a lot to this job. There's a lot to these agreements that we sign up for. There's a lot we ask our suppliers to agree to when we ask them to sign our supplier agreements for ingredients. So on this last slide here, there's just some tips to help you with this. Is find a way to be informed and stay informed. How are you going to keep up on emerging risks, emerging developments, and information? Having written policies and procedures that you frequently review, you update at a good periodic cadence will greatly help you demonstrate that process of compliance. So no training records and ongoing training and education of folks who need it in your organization. Accountability and consequences. I can't tell you how many companies frankly avoid this, but how far it goes in the demonstration of compliance and the increase to get those around the non-compliance, having them improve their behavior. And where I'm going with this is, if there is some consequence to a behavior for an operator on the line not appropriately filling out a process preventive control log timely or accurately, well, if the operator right next to him or her sees, hey, they got talked to, they were told if they don't, do this right going forward, it may result in a performance improvement plan. I better be sure I do mine right. These are the kinds of things that really do help demonstrate a culture of compliance. Partner with experts, speak up, and adopt a multidisciplinary approach across your whole enterprise and company so that truly more than just food safety owns food safety. And what a lot of folks would like to say is everyone owns food safety in our organization. Make that happen. And for more tips on that, join the next session on enterprise risk management and leveraging that framework to be able to help you with that. So with that, I'm done, and I believe that I am going to have a guest with me on stage to field some questions coming in from the chat.
Thanks, Melanie. That was quite the session. Terrifying, but true. So I do appreciate all that you presented. It was a lot to digest. So just to ask one question off the bat, what should I give my CEO? How much information does the site CEO need? Do they need to know everything? Should I soften the message to the CEO? What's the best practice there?
we need to give them metrics. We need to give them not 127 different metrics, but what I call the critical few. Those critical few pieces of data and metrics or KPIs you're probably already keeping, and they go somewhere, they flow up somewhere, and in a lot of companies they kind of stop or tap out, maybe at that VP level of food safety and quality, and then reporting up to the CEO and the C-suite, if they have an opportunity to do so at all. It's what I would call qualitative. It's the we're good, we're on track, or we're seeing some slight deviations, here's a plan to fix it. But I think what you need to do is first ask the question to your CEO, what do you need? What do you need to help you understand risk? And then let me go from a top-down approach versus a bottom-up. I'm going to feed you the data I think you need. It may not be the data they want or need at all to really, truly understand enterprise risk. Every enterprise has a different definition of what material risk means to them. In a small company, it could be $20,000. In a multi-billion-dollar company, it could be $500 million, right? And so I think the information you feed needs to be metered to what your company's definition of material risk is.
Yeah, no, that's a great response. And for more about that, again, go to the next session on enterprise risk. We'll to talk a little bit more. So 2 quick questions. I think we have time for 2 questions. The first one is, can you talk a little bit more about the whistleblower law?
I'm not an expert on that because that really falls into an employment law expertise. But notwithstanding, what I do know of it is that we as employers, as companies and as employers, are not able to prohibit an individual employee's ability to raise concerns if they think there are unlawful employment practices occurring in an environment. So with that, there's an opportunity as applied to food production that if you see something, you're going to be protected if you say something. Your organization cannot retaliate against you because you raised your hand and went, I saw something really bad, or I saw a C of A that said there was salmonella on it, and I, saw someone ship it anyway. Those are the kinds of things that the Whistleblower Act is meant to protect. So you will speak up and do the right thing and protect human health and safety.
I just want to ask one more question that came in through the chat, and it's about that insanitary conditions, how you emphasize that in there. What does that mean? What's that definition? How does FDA perceive it? Is it just a simple positive environmental result? Is it unkept space? Is there what is that definition? Is it tight? Is it big? There's a lot. There was quite a few questions in the chat, so I wanted to get that off to you before we.
I don't mean to be flippant, but yes, and it depends. It could be all of those things. It truly, it's almost like the Supreme Court definition of obscenity is, when you see it, but there's really no definition around it, right? And so based through the lens of the inspector, right, they may see, evidence of rodent droppings as insanitary conditions. The next one may not. So I think what it means to me is make sure we don't get tunnel vision, make sure we don't keep walking past the same wreck we walk past every day like I do in my home, because I desensitize to it, right? Make sure we're keeping up on good manufacturing practices, good hygiene practices. Don't give them a reason to go looking, behind or under, or have a pristine, be audit ready all the time, right? Be inspection and audit ready all the time, and you will solve all your worries about what insanitary conditions mean.
Yes, no, that's great.
Incredible. Wow. Leanne, I saw those comments and questions rolling in. I think we need a part 2 already. I'm just going to say that. Melanie, absolutely incredible. Thank you so much for your expertise, and the fun keeps going. Everyone who's attending, go ahead and click on that breakout tab. Melanie, when folks get into the breakout, anything you want them to maybe think on?
Sure. Maybe just, share what's one thing you learned, one piece of information that either surprised you or that you might continue the conversation back in your own organizations about.
Or
I love it.
maybe, or frightened you. Yeah. Surprised you or frightened you. Yeah.
Totally. Jail bad, Melanie's advice good. I think that's going to be my big takeaway. Thank you so much for sharing. Now, head into those breakout sessions, and 2:30 Eastern, we've got, I can't believe I'm saying this, the final education session of SQF Unites 2021. Of course, 3:30 Eastern, it's our closing keynote, which is Melissa Agnes. You're not going to want to miss it. And just as a friendly reminder, all attendees here at SQF Unite, you get $100 off online training credits. So $500, you only have to pay $400. Just go through your registration to sign that up. You can get your practitioner package all taken care of. A great deal. Talk about making your CEO and budgets happy. So, hey, head to those breakouts. We'll see you at the next educational session at 2:30 p.m. Eastern. SQF Unites, the fun keeps rolling.